do with restraints occurring in complex business settings. Those of us, by show of hands, who are antitrust lawyers, yeah, you probably grew up under the Arita and Hovenkamp framework, and so you've probably seen everything as vertical or horizontal, or interbrand versus intrabrand. Maybe you think of single firms or just franchises, which today I think we'll unpack that these settings are really quite a bit more complex. And so this panel is designed to talk about recent cases, some fascinating economic literature, and we'll ask questions like, what is a no-poach agreement? When is it naked or ancillary? And we'll give special attention to applications like franchise businesses and the gig economy. So I'll turn it over to my co-moderator, Karina Lubell, and she will introduce the panel.
Thank you, Doha. So you all obviously have a handout with detailed biographies of all of our esteemed panelists. So I'm just going to give a brief description of each of their work in this area. So starting immediately to my left is Randy Stutz, who is Vice President of Legal Advocacy at the American Antitrust Institute. Randy has been closely following competition issues in labor markets and is responsible for the AAI's advocacy on the subject. He's also written, certainly I think, one of the best summaries of the literature on labor competition issues to date. Next to Randy, we have Samuel Weglein, who is a managing principal at the Analysis Group and is a labor and industrial organization economist who testifies and supports testifying experts in antitrust cases with a specialization in financial markets, healthcare markets, and technology markets. Samuel also provided economic support to the division in its successful lawsuit to block the Anthem-Cigna merger. Next to Samuel, we have Marshall Steinbaum, who is assistant professor of economics at the University of Utah, where he studies market power in labor markets and its policy implications, including for antitrust and competition policy. Marshall has written a great deal on competition in various labor markets and has taken recent interest in labor competition in the gig economy, one of the things we'll be discussing this afternoon. Next to, thank you. Next to Marshall, we have Rahul, who is an assistant attorney general for the state of Washington in the antitrust division of the Attorney General's office in Seattle. And he handles labor competition matters, including investigations and litigation into franchise no-poach agreements, as well as investigations into non-compete agreements. And as many of you know, Washington State has played a leading role in no-poach enforcement. Then we have Rachel Brass, who is a partner in the San Francisco office of Gibson, Dunn, and Crutcher, whose practice focuses on investigation and litigation in antitrust, labor, and employment areas. Rachel has represented a number of franchisors, including McDonald's, Pizza Hut, CKE Enterprises, and Jimmy John's in no-poach cases. And finally, at the other end, we have Darrell Johnson, who is a CEO of FranDATA, which is a franchise-focused research and advisory firm. He is a certified franchise executive who has served on the International Franchise Association's board of directors and known as the franchise economist. He has advised franchisors, suppliers, media companies, lenders, and private equity firms. So we were fortunate to, in our discussion of franchise this afternoon, to have the franchise economist with us.
And actually, just before we get through our questions, I do want to offer a broad disclaimer. And I know some of you are going to roll your eyes thinking the DOJ is going to give their disclaimer at their own event, but bear with us. We have a panel of experts here, many of whom are working on live cases, who are advising clients. And so in order to have a fulsome, thoughtful, honest discussion, we're going to give the general disclaimer that the issues that we'll talk about today aren't necessarily the same as our employers, clients, institutions, and so forth.
So I think we'd like to start with a little bit of background. And Marshall, I'm going to turn to you to kick things off. Can you tell us about some of the recent events that have triggered interest in labor competition matters?
Yes, I don't know if this was my Great, thank you. So I have to say it's very gratifying to be on this panel. I was just talking with Ioana that to hear the Assistant Attorney General say that labor impacts of anti-competitive arrangements or mergers are of equal footing to consumer and output effects is, I think, signals a departure from where antitrust has been until pretty recently, and I think that a lot of us that have taken an interest can take pride in that observation. I guess to sort of explain, I mean, it's a little bit multifaceted how we come to be here on a panel discussing labor impacts and its overlap with antitrust. I think part of it certainly has to do with the recovery from the Great Recession, how even, so unemployment stayed high for a long time and economists were worried about search and matching issues and hadn't really focused in particular on wages. And then when macroeconomic unemployment came down, there was a lack of understanding of why, nonetheless, wage growth remained repressed, and that turned a lot of people's interest towards a sort of macroeconomic imbalance of market power in the labor market. I think kind of the inside baseball within academic economics would say that we have a lot of very interesting new empirical methods that are put to use in labor economics, and those have typically focused on worker characteristics as explaining outcomes among workers, and those methods are very good and very refined, but I think one of the realizations that at least the body of labor economists have come to is that worker characteristics don't necessarily reflect the variation in outcomes among workers, and that naturally shifts focus to characteristics of employers and characteristics of the market, including competition in the market for workers. And that has shifted the attention of a lot of great applied labor economists towards looking at issues of market power and concentration in labor markets, other related things like firm-specific labor supply elasticity that Ioana and Elena were discussing. So I guess that's and then I would say there's sort of the political angle that a lot of, I think, policymakers had been at a loss to explain the wage stagnation and other ill employment effects using the sorts of policy analysis tools that had typically been directed at the labor market. And I can just say, from many of the meetings that I was in when I was working in Washington, there was kind of this antitrust. We haven't really been discussing antitrust in a long time, at least not outside the walls of the DOJ antitrust division. And, this is a potential kind of new area where policy has previously not been directed, and people who are concerned about outcomes for workers have not previously had their attention focused. And I think that gave rise to a lot of interest on the part of political actors outside the usual stakeholders in the antitrust debate.
Thank you. I think it would be helpful now if we had a brief overview of some of the government enforcement in labor markets, and specifically the kinds of agreements that have been challenged. So I think, Rachel, why don't we start with you, and if you could tell us a little bit about federal enforcement in this area.
Yeah, I won't spend too much time on this because I think it was addressed with a fair amount of robustness starting right off the top this morning. But there have been, at least in recent memory, two prominent investigations in employment antitrust. The first being the high-tech matters that several people discussed this morning, which involved a series of 5 similar bilateral agreements not to cold call, as the DOJ described it in its own filings. The DOJ's position was that those restraints were not ancillary to any legitimate pro-competitive purpose. And as was lamented on the Economist Labor Market panel this morning, on the date of the filing of that complaint, there was also a filing of a consent decree. So in terms of what exactly motivated the government investigation, there is not a great deal of transparency, but that is sort of the bulk of what we know. More recently, there is the government's investigation into the Noor-Bremse explicit agreements on non-hiring and wage information exchanging. That's in the railroad space. 2 issues you can contrast here is the first involved companies that may or may not be horizontal competitors in the downstream market, but were alleged to be horizontal competitors in the labor market. In the railroad case, the companies are much more clearly competitors both in the upstream and downstream markets. And there, the mechanisms included not only the express agreements between the parties, but as described in the consent decrees, agreements to inform outside recruiters not to solicit or poach each other's employees as well.
Thank you. Rahul, next I'll turn to you to tell us a little bit about state enforcement in this area.
Yes. The bulk of the state enforcement in labor competition space most recently has been in the franchise no poach context. There are basically two parallel state enforcement efforts that are happening. One is a multi-state coalition that comprises about 14 jurisdictions, 13 states plus DC, that have been looking into the use of no poach provisions in franchise agreements. That multi-state coalition has secured a number of settlement agreements earlier this year. But I think it's fair to say that the bulk of the state enforcement activity here has come from my office, the Washington State Attorney General's office. We are also looking at the use of no poach provisions in franchise agreements. Our investigation in this space started, our formal investigation in this space started in the early part of 2018. Where we started initially looking at fast food and quick serve restaurants. To be clear, we don't think there's anything legally distinguishable that would make fast food or quick serve companies more liable under antitrust law. It was rather the thinking was for employees in these industries that may be making minimum wage and maybe making below a living wage, that they were uniquely vulnerable and victimized by anti-competitive provisions in franchise agreements that would have the effect of suppressing or stagnating their wages, which is why when we decided to start somewhere, we decided to start there. We secured a number of settlements through the form of assurance of discontinuances, which are just settlement agreements that are signed by a judge. In the summer of 2018, to date, as of Friday, we have secured 85 AODs against franchisors, ranging from fast food companies to tax preparation services to car maintenance to salons and barbers. Our investigation is continuing. We have a number of CIDs out. I'm sure I have a few signed AODs on my desk that are ready to file. And that is kind of the state of affairs in terms of the provisions we've been looking at. To just kind of build upon what Dean was talking about earlier. No poach provisions take a variety of different flavors, so to speak. We have seen no poach provisions that restrict hiring. We have seen no poach provisions that restrict the recruitment efforts, basically soliciting or inducing employment movement. And we have seen no poach provisions that restrict only franchisees from hiring from other franchisees. We've seen some that restrict the franchisee from hiring from the franchisor, either franchisor headquarters or company-owned stores. And then we've seen no poach provisions that just apply equally to every participant within the franchise system, regardless of whom they may be. We consider all of those no poach provisions. The connective tissue that connects all of them is basically a restriction that limits the ability of hiring or recruiting decision-making by one of the entities within a franchise system vis-a-vis an employee of another entity within that system.
Thank you. We've heard about government enforcement in this area, but private litigation is particularly interesting when it comes to labor competition cases. And so, Rachel, I'm going to turn back to you. If maybe you could talk to us a little bit about just sort of an overview of private no-poach cases that have been filed in the last few years, and maybe describe some of the labor competition issues that they raise.
Yeah, so we've seen labor competition cases in a pretty wide sector of industries. Following the DOJ's investigation, there were lawsuits in the high-tech space and in the animation space. There have been a number of healthcare-related litigations, one involving nurses in San Antonio, one involving Duke and UNC. There have been, as I think was suggested, more than a dozen lawsuits filed against franchise systems or franchisors, cases brought by NFL cheerleaders against the NFL, and others. So sort of no particular industry or sector is immune from these lawsuits. There's also follow-on litigation against Nora Bremsey and some of the other railroad-related cases. And they allege sort of a broad range of misconduct, and they have sort of been resolved or been dismissed at various stages of the litigation. Some are ongoing, some have been settled. Common things that you see are questions about the applicable standard of review, whether or not that should be the per se standard, the rule of reason standard, or the quick look standard. I would say there is no necessarily specific or clear trend in that regard. The decisions continue to be fairly all over the map and somewhat fact specific. A large number of them have been on the motions to dismiss, which I want to emphasize makes them allegation specific, not fact specific. And so you see that as well. There have been, in the railroad case, for example, a motion to dismiss the allegations on behalf of putative absent class members was filed and granted, which found that there was such a lack of predominance amongst the potential members of the absent classes that while the case could proceed on behalf of the named plaintiffs, it couldn't proceed on behalf of absent persons. Other decisions have dismissed the claims on grounds such as standing, where, for example, a named plaintiff doesn't identify having ever applied for or sought a position where they were restricted from movement in any way by the alleged no poach provision, and that's been a particular impairment with respect to provisions in franchise agreements, for example, which had a feature that I don't think I've heard anyone talk about this morning, which is that while there's a provision restricting mobility, it's not a provision that restricts mobility full stop. It's a provision that restricts mobility absent an employer release. And so that's an issue that I think we'll see percolating through the litigation as well, is what is the effect and extent at which releases were granted. They're alleged in some, but not all, of the cases involving these restraints. And then sort of at the outer end, you've seen, classes certified and cases settled, where in some cases, like the high-tech case, no decision was ever ultimately made on whether the per se or rule of reason applied, but a class was certified, Judge Koh finding that class-wide proof could prove liability under either theory, and those cases were resolved, as were the animation cases, and most recently settlements in the Duke and UNC cases. So I would say we're still at a fairly nascent place in terms of what the evolution of the case law looks like, with a number of splits and interpretation percolating through the system on motions to dismiss. How telling those will be when the courts ultimately, in the cases that aren't dismissed, engage with the facts on the ground as opposed to the allegations, I think, too early to say.
Thank you, Rachel and Rahul and Marshall, for that really helpful introduction or background. Doha?
So this morning we heard a lot about the fact that the antitrust laws apply to labor markets with equal force as output markets for tangible goods and services. So Randy, I'm going to turn to you and ask a really important question, which is, what does the consumer welfare standard require in terms of harm with respect to labor markets?
Sure. So can everybody hear me okay? First of all, thank you to the Antitrust Division for hosting this program, and to Doha and Karina for putting together this excellent panel. AAI has been following all these developments in labor markets and case law going back a few years now, and have called on the agencies to host a program like this. So we're very pleased to see this taking shape, and it's been fantastic so far. The consumer welfare standard, I think the Assistant Attorney General really said it best this morning. It doesn't mean what it literally says, that we only care about the welfare of end purchaser consumers like you and me. The consumer welfare standard protects competition throughout the supply chain. There are plenty of examples to back up this claim. You can look at the Illinois Brick and Hanover Shoe indirect purchaser rule. There's an example where we often protect businesses in the middle of the supply chain at the expense of consumers. And then certainly you can look to Supreme Court cases like Weyerhaeuser and Mandeville Island Farms, where causes of action for upstream harm in input markets have been sustained without any effort to trace through anti-competitive effects in downstream output markets. And then, of course, we have the agencies and their practices, and we can look at the horizontal merger guidelines, very explicit. Example 24 discusses a buyer power merger that inefficiently reduces supply and causes a wealth transfer, and clearly states that it's illegal even if the merger will not lead to any increase in the price charged by the merged firm for its output. So really, one question that often arises is how effects in upstream markets translate downstream. Oftentimes, enforcement in input markets is fully consistent with effects in downstream markets because supply restrictions tend to reduce output in supply markets, and that can have anti-competitive effects in output markets. But the important point is that in antitrust law, we don't require that showing. We don't look further. We look for harm to the beneficiaries of competition. And there are beneficiaries all over the supply chain, including upstream.
Most antitrust lawyers have heard some version of the following phrase, which is that the antitrust laws reserve their harshest condemnation for restraints on interbrand competition. So, Samuel, can you tell us the difference between intrabrand competition and interbrand, and why we're suspicious of restraints on interbrand competition?
Yeah, sure. Thanks, Karina, and thanks again to the division for inviting me here. I will say, I mentioned this to a colleague, that the outline that Karina and Doha put together was longer than the field exam I took in labor economics in 1996. But it's been fascinating to think about these issues. So it's a real pleasure to be here. So just very briefly, interbrand competition. I'll use an example outside of the sorts of industries that we'll really be talking about just to motivate it. Interbrand would be Whole Foods competing with Trader Joe's, okay? And there we expect vigorous competition along multiple dimensions. It can be price, it can be non-price, it can be quality of the produce, it can be service, it can be all of these things. And we expect that. And so any attempt to subvert that, any lessening of that competition is something that we would deem problematic. Intra-brand competition in that context would be the competition, if you will, amongst Whole Foods stores. Okay, and you will see obvious ramifications here, and there will, I think, be a diversity of views as to how relevant this analog is in the franchise context. But within the context of Whole Foods, we do not expect there to be vigorous competition along all of those dimensions. And in fact, we expect just the opposite. Store managers, for example, are not empowered to reduce the price of milk in their Whole Foods so that they can compete more effectively with the Whole Foods in the neighboring town. There may be some competition along some dimensions like service, right? It's not, we don't ignore entirely the prospect or the possibility that each store manager wants hers or his store to outperform the others, but it won't be along all of the dimensions that we expect a Whole Foods and a Trader Joe's to compete. So broadly, that's the distinction.
Horizontal agreements can be naked or ancillary. What's the difference? Randy, sorry.
For me, sure. So the naked ancillary distinction in antitrust law goes back to the 1890s and Judge Taft's opinion in the Addison Pipe case. Put very simply, a naked restraint is a restraint that is unadorned, not intertwined with anything else, not part of a broader efficiency-enhancing economic integration. Oftentimes, a naked restraint is an agreement to do the thing that is illegal, an agreement to fix prices or to divide markets. But restraints can also be ancillary, which is to say they can be part of something broader and something pro-competitive. And the key inquiry there is whether the restraint is sufficiently interconnected to the broader efficiency-enhancing integration. And the upshot of this distinction is that when a restraint is deemed sufficiently ancillary, it can take it can change the applicable liability standard with which we consider the restraint. So, in particular, an otherwise per se illegal violation like price fixing can be reviewed under the rule of reason. And so that's the primary upshot of the ancillary restraints distinction. It becomes less relevant. A lot of the cases we're going to talk about today involve the franchise context and vertical restraints. Most vertical restraints are already reviewed under the rule of reason. So oftentimes the ancillarity question just doesn't arise or isn't especially important. But when you have a per se claim or potentially a quick look claim or an inherently suspect, a structured rule of reason claim, the ancillary naked distinction becomes important.
Are there any recent cases, and particularly no-poach cases, that have explored ancillarity?
It comes up a fair amount. Like I said, oftentimes, particularly when there are joint ventures and other group purchasing organizations, joint selling arrangements, these are the kinds of cases where ancillary restraints questions get litigated. The Hornbook sort of test is whether the challenge restraint is part of a larger economic integration in the sense that it holds the promise of pro-competitive benefits and is reasonably necessary to protect the legitimate fruits of the main transaction. It hasn't directly come up in a lot of the recent no poaching cases that we've been talking about. The arguments have been raised. The Little Caesars case, Ogden versus Little Caesars, involved a no poaching agreement where the court did rely on the rule of reason, but on the basis that the plaintiffs didn't plead sufficient facts to allege a per se or quick look violation. So it wasn't via the ancillary restraints doctrine that the court got there.
I think the Deslandes versus McDonald's case of the recent no-poach franchise cases comes the closest. And there, as part of the court's analysis in determining that the per se rule would not apply, the court looked both at the fundamental interbrand versus intrabrand nature of the restraint, the fact that the majority of the agreements under the restraint are franchisor to franchisee, and that then also that it's an ancillary restraint to the overall franchise agreement. The court didn't particularly delineate any one of those factors as driving the ultimate decision, but looked to all of them to find that ultimately per se treatment was not appropriate. I would say that one of the places that it's addressed actually in a fair amount of detail is in the Department of Justice's interest statement, as well as their statement on their website about their view of how the ancillary restraints doctrine intersects with franchise systems. In the cases it filed in the Western District of Washington, 3 of the pending private litigations, the Antitrust Division suggested that at least on the facts of those cases, what was alleged was an ancillary restraint, went a bit further on their broader public statement and suggested that more often than not, although again it will be a fact-by-fact assessment, often these restraints will be ancillary in nature.
And so an important thing to keep in mind too is just because a restraint is part of some broader integration doesn't necessarily mean it's ancillary. And part of the issue in the Washington State cases that Rachel was referring to was sort of this question of whether the no poaching agreements were likely ancillary or likely subject to the full-blown rule of reason as opposed to possibly a per se or a quick look standard. And really the only way to determine that is to actually perform the ancillary restraint analysis and see if there's a functional connection between the challenged restraint, so in this case the no poach clause, and the broader franchise agreement. So the NCAA Board of Regents case, going back to the 80s, recognizes clearly that a restraint can be part of an integration, but still be naked. It's not ancillary simply because it's appended to to a broader agreement.
We've talked a bit about different restraints, and we've sort of mentioned in passing the rule of reason, the per se rule, and the quick look. Can we just briefly, for the good of the audience, talk about those rules and why they might matter for plaintiffs and defendants in antitrust cases? Randy?
Sure. Might have been good to start out with that. I apologize. Of course, the per se rule is the strictest antitrust liability standard. It's reserved for naked horizontal agreements that always or almost always tend to restrict competition. And the upshot of applying the per se rule is that a plaintiff is not obligated to prove market power or anti-competitive effects. In a Section 1 case, it simply has to prove agreement. If it's a private plaintiff, it has to prove antitrust injury and damages. But market power and anti-competitive effects are irrebuttably presumed. At the other end of the spectrum is a full-blown rule of reason case. These are cases where a plenary market examination is required to understand the nature, purpose, and effect of a restraint. Plaintiffs are required to define a relevant market, prove market power in the market, and prove that the agreement is anti-competitive. And the full rule of reason operates under a burden shifting framework. The plaintiff has the initial burden to prove power effects and harm. And if it does so, the burden shifts to the defendant, which can offer offsetting efficiency justifications. And if the defendant succeeds in doing that, the burden shifts back to the plaintiff to prove a less restrictive alternative or that the agreement is on balance anti-competitive. In the middle, historically, is the quick look rule. It's not a single rule, really, and the law around quick look has evolved quite a bit over the years. But the original premise of quick look was that there are some agreements which are their anti-competitive effects are obvious. We don't need to inquire into the anti-competitive effects, but there's some attending feature to the restraint, some novelty, which might allow a court or create a desire in a court to peek at any possible efficiency justifications. And so they would perform a quick look. It would take a quick look at any efficiencies justifications. If they were legitimate, the case would revert to a full-blown rule of reason case. If they were not, it would revert to the per se rule. Since then, the court has made clear that we don't have just 3 strict categories. The rule of reason can be abbreviated in any number of ways. The applicable line from Justice Stevens in the California dental case is we need an inquiry meet for the case. And so one solution has been what's sometimes called a structured rule of reason or an inherently suspect framework pioneered by the FTC and approved by Judge Ginsburg in the Polygram holding, which creates, similar to the per se rule, it creates a presumption about market power and effects, but it's a rebuttable presumption. So plaintiffs don't have to prove market power, don't have to prove anti-competitive effects, but defendants are offered an opportunity to provide efficiency justifications.
So I want to shift now to talking about franchises in particular. They are fascinating business models, and undoubtedly some of the most interesting no-poach cases of late relate to restraints in the franchise world. So Darrell, I want to turn to you. At a high level, can you describe what a franchise business model is, some common ownership structures, and sort of give us a sense of the business?
Doha, I'd be happy to, and good afternoon. I have the luxury of being here as a researcher and FranDATA who sits in the central nervous system of franchising. We're the objective third party that deals with the business model and looks at it, understands it, and explains it. And it's confusing. As recently as the last hour, somebody asked me about the Starbucks franchise, and Starbucks is actually not a franchise. We have a lot of misunderstandings about what is and what isn't. What we'll do here is we'll focus entirely on the business format franchise model And I'll give you a quick understanding of it and then show you where there's some misconceptions that go along that apply directly to, I think, what we're talking about here. First of all, business format. There are 3 tests under the FTC franchise rule that constitutes a franchise for FTC rule purposes and precipitates a whole series of regulatory responsibilities on the franchisor. And those 3 rules are that it's the use of a trademark. And in that, let me give you a quick example. Most of you here have your personal physician. And your personal physician, I'm guessing you don't know offhand who he or she actually is a part of. It's just your personal physician. That's an individual. The brand is the individual. In the case of either urgent care or worried about where one of your parents is going to, whether they're going to have aging at home and you want somebody to be in there with them that maybe has some medical experience, you care about the brand. You don't care about the individual that goes in there as much as does this brand have a good reputation to be able to deliver the service that you expect. That's where franchising lives, is in that brand distinction. And that's where the trademark requirement is the driving force behind it. The other 2 rules, one is that there's consideration between 2 entities, between the franchisee in the case of the licensed user of that brand and the franchisor, who has the 3rd responsibility, which is significant control over the method of operation of that franchise, because they have brand risk associated with it. And therein lies a lot of the rub that you in this room represent on one side or the other. Franchising is found anywhere in the U.S. where there's rapid growth and that brand component has value. There's over 220 sectors. There's 3,800 active franchise brands in the U.S. today. And now let me give you a sense of where there's a distinction in somewhat of the misunderstanding of how some of this is actually used. A lot of it precipitated, the anti-poaching issue was precipitated by the Princeton study. FranDATA provided the research information with which that study was done. One of the principal, in fact, I think the central tenet of that is that anti-poaching clauses exist to reduce employee turnover. I will tell you that in the roughly 20-some years of being involved directly in the research business with franchising, I've never heard a franchisor say that. By and large, the reason they have had anti-poaching clauses in their agreements is to enforce proper training at the franchisee level under the significant control of the method of operation of that franchise business. Now, I'm not here to argue that that's right or wrong, or that it's the majority of the time or the less amount of time, but I will tell you that most of the time that provision is to protect the method of operation wherein a franchisee who chooses not to do any training and just poaches the employees of another franchisee, it's to try and force, as part of the training program, force better training of employees across all of the franchise system. So that is just an example, I think, of where we see a lot of the distinctions in the misunderstanding of franchising. One other thing I will note is just the sheer complexity of once you get inside the business model. The franchisor is responsible for 12 functional areas of franchising in order to execute the business model. They look downward from the franchisor. You have franchisees. Well, franchisees are legal entities. They're formed, they're all incorporated entities. So we think of franchisees as people. They're actually incorporated entities. The owners of those franchisees are the people who are oftentimes assumed to be the franchisees. But the corporate structure that they have, almost all of them are either corporate entities, rarely partnerships, but now you get into the complexity of it. There could be a single unit franchisee with one legal entity. That legal entity may own 2 units, or 22 or 222 units. That may own it in one brand, or it may own it across 3 brands. That legal entity may, each time the owner of that business wants to add a new unit, they may incorporate a new entity. So you have all of these complex structures that are existing underneath how one franchise system operates. I'll stop there.
Thank you. So I want to go back to something you just mentioned about sort of to whose benefit is a no-poach clause within a franchise agreement. Can you tell us a little bit more about, I mean, the origins of no-poach clauses and franchise agreements? And I mean, if we had to think about the clauses as benefiting someone, who is the someone?
Yeah, well, let me give you some statistics. In the Princeton study, there were the request by Princeton University was to look at all franchise systems with more than 500 franchised units. There was 156 brands that were identified that had some type, or that were above 500 units in operation. Of those 156, 58% of them had some type of anti-poaching language in their franchise agreements. Those anti-poaching language elements ranged from a very passive kind of inert statement to a very strong one. Some of the language with some of the brands were both at the franchisor to franchisee level, and some of them were from franchisee to franchisee, and some of them were from franchisee to affiliate of the franchisor. In franchising, typically, most franchisors don't own a lot of company units themselves. Oftentimes in franchising, and when I say franchising, I'm not talking about all of the big guys. I'm talking about the 3,800 minus the 156 that have more than 500 units. The vast majority of them operate with few company units because one of the primary reasons to franchise is to use other people's money. So that's how they get started, is to push down the responsibility for the capital formation to the franchisee. And because of that, there's typically no conflict at all between the franchisor and the franchisee, at least from a competitive standpoint. There are always exceptions. If you've seen one franchise system function, you've seen one. They all have a little nuanced difference to them. And I will say, as a publicly traded company, Regis Corporation in the hair care industry, they have company brands, or brands that are only company units. They have brands that are only franchised units, and I think they have a little bit of each. So you have a lot of mix of all of these different things going on, but typically those agreements that were, some of which go back 20, 30 years in the early formation of it, and it was early on was largely driven between franchisor and franchisee. Today, it's largely between franchisee and franchisee for the purpose of things like training.
Doha, I'd like to build a little bit off of what Darrell was talking about. So in our investigation, we've looked at hundreds of franchise systems, and for the purposes of this public discussion, I'm gonna back out everything that I can't talk about because it's in an early phase of the investigation. But of the ones that I can generally speak about, we've looked at upwards of 130 to or over 150 franchise systems. It is not an identical set to what was in the Princeton paper, in part because there were some companies on the Princeton list that do not have a presence in Washington, and there are a lot of entities that are below what the threshold was for the Princeton list. From that macro view, we have seen that about 65% of those franchise systems had some form of no-poach provision, which means 35% didn't. In talking to the counsel in discussing our investigation and our enforcement efforts, we've heard basically a repeat of a couple of similar refrains with respect to how these no-poach provisions got into the franchise agreement and what their purpose is. The first thing that we heard off the bat within the first few sentences of almost every call is, we've never enforced these provisions. We've never enforced them, and we actually have no idea how they got into the franchise agreement. The second refrain, which is, it sounds a little bit incredible, but I actually find it plausible, is we did not even know this provision was in our franchise agreement. This is boilerplate language. We just adopted it. The first we heard about this was when you sent us a civil investigative demand. From my take, I mean, the way I've been describing it and the way I have no reason to disbelieve any of what has been told to me is that for a lot of the franchise systems today that have these no-poach provisions, they're essentially vestigial organs. It's literally like an appendix. Like, it's there, you don't know how it got there, you don't know what it does, and you're happy to get rid of it if it causes a problem. And that's essentially what we have been seeing. So about 65%, that percent has been relatively consistent throughout the various phases of the investigation, when we're looking at a smaller number, if we're looking just at fast food, or if we're looking at the current amount that we have right now across multiple industries.
I could confirm that in many, many cases. We're talking about a regulatory document that has evolved through the practice of law firms who have specialized in franchising over decades. And by and large, it's always been additive. We found something new that we can do, they add it. They don't subtract, and over time they've evolved. We have an inventory, a library of regulatory documents, largest in the world, probably 65,000 documents. I can assure you that some of those clauses are back 25 years ago, and no one today knew why they were there. And yet new franchisors that get started go to those law firms and they just take the boilerplate and drop it in. And there are a lot of terms like that they're there if in case you may need it someday. And that's what surprises a lot of franchise executives when they're confronted with a question like this.
Doha, I think Darrell makes an interesting point. That's something else I think we'll see wind its way through the pending civil cases, which is that this is a regulated industry. All of these agreements are filed every year with the FTC, with each of the states in which the companies do business. Certain states, like Washington, make clear that when you file it, the filing and approval of it says nothing about the state's ability to later enforce laws against it. Not all states say that. But I think that differentiates this from, and may have a bearing on the position the DOJ took, and I'm not speaking for you at all in any way, but this is not a provision that was sneaking around in the dark. Like so much of what we think of as unlawful conspiracies. There was nothing secret about this. It's, it's if anything, it is, the most open and brazen conspiracy that has ever happened, in that, these 56,000 documents Darrell have described, every single one of them was filed with the federal government and with the state AGs. And, what implications those will have as the cases wind their way through a litigation, I think we'll have to see. Depends on the state, depends on the agreement, depends on the law that's being asserted. But it is something I think that very much differentiates these cases from maybe something like the railroad case, where, other than that it was shared with outside solicitors, it was not something that was sort of open, notorious, available to be scrutinized on the public record.
There's a lot to unpack there that I won't respond to in this setting. But I will only say that we have often heard, I did not know this conspiracy was illegal. And we have many sections that enforce the law in regulated industries. But I take the point that it will be interesting to see how the courts grapple with those facts.
And the one thing I would like just to add for that for the other enforcer at the table is I don't necessarily disagree with the objective statement that these were not secret agreements. They were informed franchise agreements that are on file and regulated with the state and shared openly with anybody who wants to look at a franchise agreement. I think what's interesting about where we are now in antitrust law, which is what's actually really exciting about this workshop, is that our understanding of labor economics has been significantly evolving over recent many years, and in part because of the Princeton paper and how that brought to bear the anti-competitive effect of these open and notorious agreements is kind of what has sparked the enforcement effort. So it's not that they were secret or it's not that they were open and we were okay with it. It's that they were open and we just, as enforcers, may have just been focusing too much on output markets and not enough on the input markets.
And maybe, sorry, just one more thing to add on this.
I didn't think the franchise background question would spark this much discussion.
From an antitrust perspective, of course, the sort of the intent is not relevant in terms of the economic intent, if you will, is an important thing to get to. And just to go back to your very question, which was sort of at whose behest are these agreements being imposed? It's important to think about whether, however they found their way into these contracts, are they are they serving the interest that Darrell mentioned in terms of promoting investment and training, or is it a way for a franchisor to give franchisees a means to capture more of the surplus created by their workers? The former would be an efficiency rationale. The latter would not. That's just the elimination of competition. It's just making people more wealthy by eliminating competition. So it's important to think about. The analogy that's sometimes used is for resale price maintenance. And the Supreme Court in Legion differentiated between RPM agreements that are initiated by the manufacturer versus agreements that are initiated at the behest of the dealer. And there's really not much good justification for the latter. A dealer really benefits from RPM by just keeping prices high and preventing competition from discounters. So if anyone's interested, now would be a good time to go back and read the amicus brief by Mike Shearer and Bill Cominor to AAI advisory board members, which the Legion Court cited and discusses that point in some depth. I think it's relevant here.
So Samuel, could you tell us a little bit about your view of how we should think of competition for workers within a franchise system?
Sure. Let me give a little bit of context so that we don't put the cart before the horse. And let's think about franchising as a means of distribution. So you have a spectrum or a distribution of ways in which firms can distribute the products that they manufacture, right? So this will be simplified, and there can be lots of permutations, but I think it's helpful just to set it up this way. So at one extreme, you can have a company that designs and manufactures, distributes, sells its product, right? So it's a vertically integrated firm. And from the consumer's perspective, from the customer-facing perspective, one of the benefits of that vertical integration is the firm has the ability to create a uniform product and a uniform experience, right, regardless of where you are. So a prime example, and again, this is not a pure play, I recognize that, but would be Apple, okay? Think about Apple. I walk into an Apple store. I know exactly what it is I'm going to get in terms of product, pricing, service, all of that experience. Then you have the other extreme. At the other extreme, you have firms that will produce a product, manufacture a product, and then distribute it to distributors or directly to retailers who will sell it largely under their own terms. And this, alludes to RPM and other things that we'll maybe come back to in a few moments. And here the experience can be far more heterogeneous, okay? So for example, I'm in the market for Adidas running shoes. I could go down the street. There's a store around the corner called Marathon Sports. And when I go into Marathon Sports, even before I take off my shoes, they'll be sizing me up in terms of, am I an overpronator, an underpronator, all these things. They'll give me all sorts of shoes. I can go outside and run up and down the block. Amazing customer service, and I will pay for that, right? So I will pay a lot for those Adidas. Then you have, in the middle, you have Models. Okay, I go into Models, and there may be some amount of interaction with the salesperson, largely to see if that color or that size is available in the back. I haven't been able to find it in the jumble of running shoes that is Models. And so there will be some amount of user experience and sales and service, but limited. And then I might go to TJ Maxx, where there's literally none. Whatever is on the rack, and this is not a slam on TJ Maxx, right? This is, you get what you pay for. You pay less at TJ Maxx than you do at Models or at Marathon Sports. So franchising sits somewhere in the middle between those two extremes. It's a hybrid of sorts. I'll use as an example, not to pick on it, not because I think there are any no poach agreements or anything like that, but I'll pick on Dunkin' Donuts because I'm from New England. And Dunkin' Donuts is perhaps closer to the vertically integrated model than it is to the independent distributor. I walk into a Dunkin' Donuts and I know what to expect in terms of the variety of foods that are offered, how the coffee will taste. It's a very uniform experience. And this is due, at least in part, and Darrell might be able to speak to this, well, certainly could speak to this better than I can, that the terms of the franchise agreement can be quite specific in terms of the types of supplies that are used, inputs, and so on. And in a sense, just to invoke very briefly Oliver Williamson, the idea is you have, I knew that would get a reaction. And the idea is to write as complete a contract as possible. You're not vertically integrated, but the idea is to get as close to that perfect, complete contract as possible. And this brings us back to this notion of interbrand competition. There is not the expectation, the owner of the brand, of the Dunkin' Donuts brand, is not expecting the franchises to compete with one another on all of the dimensions. I can't walk into a Dunkin' Donuts near my house and hope to buy the local franchisee's grandmother's chili, right? That's not a thing. I'm expecting a particular experience. And if I don't get that experience, that can have impact on the brand. And so the franchisor is looking intentionally, and we recognize this, and this is true both in terms of, not just in terms of, this isn't just a labor thing. You know, we have exclusive territories. Often we have requirements in terms of the supplies. The idea is to promote the brand and not to harm the brand. And so another thing you won't see, for example, at a Dunkin' Donuts, you won't see a Dunkin' Donuts offering a promotion that's meant to specifically promote that store. You don't have a coupon. That won't be given out. That's at this location only. You can get some sort of specialty. You may have it regionally, but you wouldn't have it at a specific location. And maybe that's a useful litmus test, not definitive, but that might be a nice little litmus test where you have specific in-store promotions that do in fact pit one franchise against another. So auto dealerships, and maybe Darrell will say, nope, that's not really a franchise. Is it a franchise?
No, it's a product distribution.
Okay, but in any event, auto dealerships, they have many common features as franchisees, and they do compete vigorously on price with one another, and sales managers have pots of money from the manufacturer that they can use at their own discretion to compete for your business. So the question ultimately is, does this harm the consumer? The fact that Dunkin' Donuts is restricted, or the franchisee is restricted in certain ways. And the answer is not necessarily. So some consumers, if we lived in a world, the counterfactual, without any vertical restraints, so the franchisee could do whatever it wanted to do, it just licensed the brand, but then could offer its own products, its own coffee, and so on. So some consumers may be better off. They may just value the ability to buy donuts at the lowest price possible, regardless of their quality. They may be better off, but other consumers will be worse off. They will not get the coffee they expected. They won't get the experience that they expected. And in the long run, consider what might happen to Dunkin' Donuts, or what Dunkin' Donuts might choose to do. Darrell talked about franchises using franchising as a means of expansion, of funding expansion and sharing risk. And that's undoubtedly true. And if Dunkin' Donuts can't expand without losing control of its brand, it might choose not to franchise, and that could be a loss of surplus, right? Today, Bob could open a donut shop called Bob's Donut Shops, right? But he doesn't do that. Bob wants to license Dunkin' Donuts, and so and why does Bob want to license a Dunkin' Donuts instead of opening Bob's Donuts? It's because he knows that that's what the consumer is looking for, and so that ultimate loss of ability to license the Dunkin' Donuts name could harm consumer welfare.
Sure.
Yeah, so thank you. I think that raises a lot of important questions that exactly motivate why this panel is taking place. I mean, for one thing, I think there's a lot of interesting research to the effect that because we have permitted the types of vertical restraints that permit the expansion of these franchising networks that totally eliminate any discretion that the franchisees have within the network. I think that reflects the market power that the franchisors recognize in the brand that they're licensing, as you just referred to. The upshot is that then the one margin that is available to them is to squeeze workers and worker pay, and hence the arrival of the no poaching agreements and the other restrictions that we're discussing in the context of antitrust enforcement now. So I think, and to kind of put to wrap that kind of discussion up, you said that if we didn't have the ability to use vertical restraints in the franchising context, that would result in a reduction in consumer welfare. Where the whole point of antitrust enforcement in the labor market is that we don't allow potential benefits to consumers to offset the harm to competition that happens in labor markets. If we care about harm to competition in labor markets, then it would be an excuse that everyone would use that, we need this in order to benefit consumers. I don't think that that's what the antitrust laws support. I don't think that that's what the consumer welfare standard is about. And I hope that a lot of the discussion from the Assistant Attorney General and others today would count against that sort of claim.
I'd like to give you one more fact associated with what you just said. Today, 56% of all franchised units in the U.S. are owned by multi-unit operators. Most of the multi-unit operations, Duncan's a good example of this, 10, 15, 3, 5, 8 units, they are usually contiguous units because a franchisee will typically want to expand their territory because their understanding of that local market is strongest. And rather than having a unit in this town and a unit in the next town over, or in this case in the district and in Arlington and in Bethesda, they would want to have contiguous territories. Duncan, as many brands that have encouraged multi-unit sales of units, have followed that pattern. It's an efficiency pattern. The point, though, for purposes of labor is they're owned by the same entity. They're owned by the same operator. And it may even be 2 or 3 legal entities embedded in this. It's the same operator and the same general ownership structure at the franchisee level. And I think that's one of the key things when the Princeton study came out, and there was some reference to it at the end of further analysis that could be done. That was one of the key things that was not looked at all. And yet today, the majority of franchising is operating in the multi-unit environment.
So we'll come back to what franchises or which franchises might find value and what those values might be for no poach agreements. But I want to make sure that we cover the antitrust categorization of the restraints. So Rahul kindly articulated a few different permutations of no poach restraints and franchise agreements. He talked about franchisee to franchisee restraints, the kind of vertical restraints from franchisor to franchisee, and then there's the franchisee to affiliate categories. Rahul, can you walk us through how we should think about those restraints? I mean, assuming we're in a world where we have to categorize them as vertical or horizontal, what are they?
I can tell you how I view them, and I'm sure there would be some debate about this at the panel, but from my perspective, I think one of the sources of confusion with respect to the nature of the question is with respect to the output market, the relationship between a franchisor and a franchisee. Like the franchisor is in the business of selling franchises. The franchisee is in the business of selling sandwiches or burgers or whatever it may be. So you look at it from a consumer standpoint, it looks vertical, right? But when you're thinking about it from an input market, from a labor standpoint, the fact of the matter is these provisions restrict the ability of one of 2 market players from hiring or recruiting the same unit of labor. Both market participants inherently want that same unit of labor. They are in direct competition in a horizontal labor market for an employee. It doesn't matter what their output market is. It doesn't matter what their business is. In the labor market context, they are horizontally competing for the same talent. The no poach provision by itself evidences the fact that they are in competition. It makes no sense if they weren't competing for the same employee, why they would have that provision to begin with. So From a personal perspective, as well as why we are enforcing it the way we are, we have a very difficult time seeing how a no-poach provision is anything but a horizontal restraint in the labor market.
Does anyone want to follow up?
Yeah, well, first of all, I would just say I agree with that. I think that we have to analyze the competition in labor markets reflected by the no poaching agreement. I would also say that the idea that it would change the competition analysis, whether it was horizontal or vertical, seems somewhat misconceived to me. If we care about competition in labor markets just as much as output markets, the kind of different antitrust scrutiny for vertical restraints arises from the economic analysis that says that vertical restraints have potential efficiency benefits in output markets. It says nothing about the fact that they may be pro-competitive in input markets. And in fact, for the reasons that Rahul just said, we would expect that they would not be. Even if we granted that the market structure was vertical franchisor to franchisee, there's absolutely no reason to suspect that would mean that any agreement between them not to hire from one another in labor markets would have some sort of efficiency benefit. Certainly not in labor markets. And if it's in output markets, why does that vitiate the reduction in competition in the labor market?
And I think, that's a really good insight, Marshall. And the fact that the no-poach agreements are not agreements between the franchisees, right? If it arose amongst franchisees, then certainly it would be a horizontal agreement. The fact is it's arising. So the mechanism is clearly a vertical one, right? It's an agreement between a franchisor and franchisees. Now, there's reference to competitors, for sure. The same is true whether implicitly or explicitly with geographic restrictions. But again, it's going to come down to what's the motivation. And if the motivation here is about promoting the brand, that is a vertical concern, even if it references other franchisees in the area.
Yeah, I just don't see that there's a difference in the competitive impact arising from the fact that the agreement is between franchisor and franchisee. The franchisees are entering into that agreement because they're contracting with a brand where they know that everybody else has contracted in such a way that they're not going to be poaching workers from one another. So it's just not, I can't speak directly, obviously, to the legal aspect here, but it seems kind of odd to me that we're having this, to some degree, formalistic debate about whether the agreements are horizontal or vertical, premised on, first of all, the economic assumption that the vertical agreements benefit consumers when we're not talking about the output market, and second of all, we're not paying attention to the fact that this is, affecting a agreement that reduces a competition in labor markets, whether the formalization of the contractual parties is that they are at different segments of the supply chain or not at different segments of the supply chain.
Yeah, I agree that the formalistic nature of it, and by the same token, I think if some of the stores are franchisor owned, to me again that's not particularly relevant. The same sort of muted competition as between franchisees occurs between franchisees and franchisor-owned stores. There's the same sort of adherence to pricing and promotion of the product and geographic market. So I agree with you that the sort of formalistic debate, is it horizontal, is it vertical, isn't relevant. I think I at least see a different sort of argument, or maybe I see the consumer welfare standard discussion in a slightly different way than the way you're describing it. And I don't have a definitive answer, which is, is there a right answer or a wrong answer? But it feels like we're perhaps conflating two things. The consumer welfare standard. The justification for pursuing a case upstream in a labor market is to say that even if we don't observe a reduction in output downstream, that's not going to deter us from bringing a case. So if there is impact upstream without a commensurate impact, a supply side impact, right? The workers supply less labor, and therefore the producer produces less. And so we move along, that change moves us along the demand curve, but it's not a change in demand. We move along the demand curve and the price increases because of that outburst. We don't require that. That to me is the question about the consumer welfare standard. There is a separate question, I think, and I'm not sure those two necessarily have to be linked, which is, well, suppose that we have both that upstream effect And we don't have a supply side effect downstream, but we have a demand side effect downstream. And so because you don't have turnover disruptions, we heard a lot about that from Professor Ashenfelter, notwithstanding Darrell's warnings not to invoke that. But that has a demand side element to it as well. Right, the franchisee and the franchisor potentially are looking to avoid disruptions to their operations because that's going to affect service. It's going to affect wait times. It's going to affect quality. The fries get soggy, things like that. These are demand side. So it's a different effect than the supply side. And I'm not sure that the consumer welfare standard or the articulation that the Assistant Attorney General gave today necessarily rules out the possibility that those benefits downstream that are on the demand side can't offset or be counted against the harm upstream.
Yeah, I mean, I guess what I would just say to that is, it sounds to me like you're saying, maybe I misinterpreted this, that the reason why we would care about upstream effects in labor markets is ultimately motivated by concern about output and the economic quality of downstream markets, even if you don't actually have to show downstream effects in downstream markets to establish an antitrust violation. If that's what you're saying, I just think that isn't why we would care about competition in labor markets. If competition in labor markets is just as much the concern of the antitrust laws as competition in output markets, that it isn't because we assume that the harm to competition in labor markets would have some sort of output effect. It's because we care about the welfare of workers just as much as we care about the welfare of consumers. And if the welfare of workers has been harmed, including through the franchising business structure, where we have essentially legalized vertical restraints that permit franchisors to tell franchisees what to do in almost every context, if that's harming workers if it's harming workers by reducing competition for their labor, then that is a violation of the antitrust laws. It doesn't matter what the output effect is.
So this is an important point. I want to make sure that we solicit other views. I mean, I think the threshold question is, in these no-poach cases, assuming some form of the rule of reason applies, there's presumably an opportunity for the business to offer a pro-competitive justification. And I think we've heard a little bit from Samuel and Marshall, but I mean, where does that pro-competitive justification lie? Does it have to be in the labor market, or can it be in some output market?
I think what I hear Samuel saying is that it doesn't have to be one to the exclusion of the other. You may have pro-competitive benefits in the labor market. There may also be pro-competitive benefits in the downstream market, and it's appropriate to be considering both when you're looking at alleged anti-competitive effects. You're not limited to looking in the downstream. In the up or the downstream market, which I think would make sense in any vertical relationship. It's how we look at things like resale price maintenance. It's how we look at things like the dual distribution models, which are evaluated under the rule of reason. And in dual distribution, for example, we do look both upstream and downstream when we're evaluating pro-competitive and anti-competitive effects to decide if something satisfies the rule of reason.
So one thing we don't do in antitrust, and I want to make sure I'm understanding Marshall's position accurately, but we don't do multi-market balancing. At least we don't do that in merger law, and we don't do it under the rule of reason outside of the ancillary restraints framework. I think we can all agree on that, or maybe not, but that's basically, it's sort of a central premise of antitrust law. It's the choice to do a consumer welfare standard instead of a total welfare standard. We are not willing to accept anti-competitive harm to one group of market participants because it makes a different group of market participants better off. The efficiencies, if they're going to overwhelm the anti-competitive effects, have to be in the same market. They have to make those injured consumers better off. And this is, you can think about National Society of Professional Engineers, the ruinous competition defense. They said if you allow engineers to compete on price, prices will get too low and bridges will collapse. the court said that argument is a frontal assault on the Sherman Act. We don't accept the argument that it's okay to restrain competition because it serves some greater good. In merger law, this rule is actually spelled out in the merger guidelines. In its footnote 14, the out-of-market benefits rule comes from Philadelphia National Bank. It's the idea that the language from PNB is to the effect that we don't do an ultimate reckoning of social and economic debits and credits for merger law. And the reason in that context is that exercise is beyond the competency of courts. That decision is left to Congress in terms of choosing, whether to make one group, subsidize another group's benefits by accepting anti-competitive harm. It's just courts are not competent to weigh those kinds of decisions. So that's why, in the merger guidelines, the efficiencies have to offset the harm in the relevant market. So I think that's a well-accepted principle. Where it gets tricky and difficult is when you look at some of the ancillary restraints cases and the cases that maybe don't specifically invoke the ancillary restraints doctrine, but that involve joint ventures, cases like Board of Regents and BMI, for example. The way I like to think of that principle is it's, the ancillary restraints test should sort of mirror that inextricably intertwined test in the merger guidelines. It's when you literally can't separate the two restraints when they are one, when they're so fused together that the challenged restraint is subordinate and collateral in the sense that you can't examine it independently without examining the entirety of the collaboration. That's almost like the exception that proves the out-of-market benefits rule. That's sort of the one instance when you have no choice. But if you have a choice, you don't allow markets benefits in one market to rescue conduct that causes harm in a different market.
So one thing I just wanted to follow up on what Rachel said. So just to be very clear, I'm certainly not ruling out the possibility that there are these upstream effects, right? And we've talked about different motivations for no poach agreements. There can be a turnover effect, and the turnover effect could be more about preserving the brand. That when there's too much turnover, particularly within the system, right? We talked about ownership within a particular area. There can be real echo effects, right? So let's say you have a bunch of Dunkin' Donuts, and Dunkin' Donuts 1 loses an employee, and the most natural place to replace that employee is from franchise 2. And so franchise 2 then poaches from franchise 3 and 4 and so on. There can be real, so that one separation can have real effect throughout the system as the poaching just continues on in an area. And that's a brand, so that could be more of a brand issue. And there, I think, the points that Marshall's raising and that Randy's raising about where are those benefits and should those offset, to me, those are really interesting open questions. But you do also have certainly motivations. Randy talked about this. Darrell talked about this, and you have motivations that really pertain to the free riding and to the training, right? That the whole purpose of the no poach is to preserve incentives. We haven't talked so much about how this works, but the point would be if I'm franchise 1. I'm in Brooklyn, and I do a really good job of training my people. Franchise 2 in Manhattan skimps on the training, and whenever it has a vacancy, it poaches from the Brooklyn franchise, and maybe pays a bonus that the Brooklyn franchise can't match because they've used funds to train with high quality investment. The goal through the no poach is to prevent that free riding. To prevent the Manhattan franchise from poaching from the Brooklyn franchise. And that preserves the Brooklyn branch's incentive to continue to provide that training, which it might lose otherwise. If poaching continued to happen and they kept losing their investment, they might stop providing that high quality investment. And there could be benefit to the worker as well by preserving that and by allowing the worker to gain what we call, I think we talked about this in the morning, transferable human capital, right? We make distinctions between firm-specific human capital and transferable human capital. Here, there's the potential, in some instances, it's not going to be in every instance, but in some instances, if you're working, you're learning how to fix mufflers or replace brakes, if you're getting general managerial skills, these are human capital skills that you can then transfer. The worker will be able to benefit from that as well. And so I don't want to rule out the possibility that there are also motivations or benefits upstream, and it's not just downstream. One just thought experiment, I'm going to throw it out there for people to think about, but your comment about ancillarity and joint ventures, this took me down a rabbit hole. I was on the Acela, so nobody could call me. It was fine. But suppose we thought about franchise agreements as a series of joint ventures, okay? And you have the brand. The brand brings with it know-how and the brand itself. And the franchisee brings the funds, the financing, and the local market knowledge. And you know, for some antitrust issues and for some ancillary restraints, it's to me at least easier to conceive of why we might countenance a restraint in the context of a joint venture, right? You know, we've come together to grow this brand in Atlanta, right? That's our joint venture. We don't have a presence in Atlanta. Let's grow the market in Atlanta. There's going to be lots of interaction between us, and this maybe speaks more to in the context of no poach between franchisee and franchisor or headquarters, right? So we want that to succeed, and there's going to be contact between our employees, and if there's poaching back and forth, this joint venture won't work, and we will not be able to dominate the donut market in Atlanta, and so. In some respects, I found it easier to think about the ancillarity issues when I thought about these as joint ventures. But I don't want to derail. I mean, in some sense, it's helpful because it gets us away from vertical versus horizontal. And so I found it natural and useful in that respect as well. But we don't need to reorient our entire discussion around joint ventures.
For sure. So I want to make sure we have enough time to cover the gig economy, but Samuel, just one more question back to you on franchises. You talked about training and free riding justifications. Does that hold up as a rationale in the case of relatively low skill, high turnover, or entry-level workers?
Yeah, so this is another rabbit hole, maybe. But especially when you overlay minimum wage, I think it gets complex and interesting. So here's the thought experiment, okay? In the absence of a no poach and in the absence of a minimum wage, suppose that my worker, without training, the value or the wage that they would earn is $9 an hour, okay? Now, in Massachusetts, the minimum wage, I believe, is $12 an hour. Don't quote me on that, but I believe that to be the case. And so that floor is binding in this instance. And so I pay my worker $12, even though without a minimum wage, I would pay $9. Now, suppose that as a result of a no poach agreement, I now have the incentive to provide my worker with high quality training and investment to the point where the worker becomes more productive. And as a result of that greater productivity, the greater training that the worker now has, I would, again, in the absence of a minimum wage, I would pay them $11. So their wage without the minimum wage, without the binding floor, would be $2 more. But because I'm still in Massachusetts, I still pay that person $12. So the question is, here we have a pro-competitive effect. It's upstream, so we don't have to get into any of the debate about does benefit downstream, does it counterbalance harm upstream? Here we've got the benefit upstream, but is it really a benefit? Because the worker in both situations, with training, with no poach or without no poach, is still getting the floor, the $12 per hour. So to me, that's a really interesting question. I'm not quite sure how to resolve that question. I mean, the other thing to think about, we heard, I think, competing statistics this morning about the implications of it being, do we see an effect on low-skilled workers? And I think this issue will pertain particularly to low-skilled workers. There may be, so maybe we don't count that as a pro-competitive effect because of the wage floor. By the same token, there may not be an anti-competitive effect, right? Where you have geographies that are fairly local, so my alternatives as a worker don't really take me to the next franchise. You know, that I wouldn't travel 5 miles in any event, and so maybe the no poach doesn't really have an effect, or there are many options. And that, again, that's not always going to be the case. Dunkin' Donuts is a poor example. I'm told that there's a Dunkin' Donuts every 1.5 miles in New England. And so that argument might not work for Dunkin' Donuts, but it might be true in other circumstances. And so, you know, on the one hand, it's really complicated upstream, and is there a pro-competitive effect for low-skilled entry-level workers? There may not be a downstream, an anti-competitive effect either.
If I may, let me give you a not upstream or downstream, because I represent the business perspective here, but let me give you across the street perspective. When we talk about low wage, we talk about generally lower skilled or underskilled employees. The franchise business model is largely, as it relates to those type of workers, we always think of QSR. So let's think about QSR for a moment. I am now providing, and the franchise business model does this really well, the training requirements in order to meet the brand standards. Training is a really important part of the discipline to create the consumer expectation of consistency and uniformity, the two hallmarks of what the franchise business model represents to the consumer. In order to get there, you have to have consistency and uniformity. To do that, you have to have employees that deliver consistency and uniformity every day. In order to get that, you have to provide training. And the training that lower skilled, lower waged employees get generally in franchising are around foundation skills. And there's starting to be a body of analysis around this that really is becoming meaningful. What are foundation skills? Skills, you know, how do you work in a team environment? Almost every franchise, at least on the retail level, has some level of team. Training with consumer interaction, customer service, training around technology, at least it relates to POS and things of that sort, responsibility, things that are basically foundation skills by which lower skilled employees build their careers. Now, when it comes to anti-poaching, we can think of it in the context of franchisee A and franchisee B within the same system. But there's across the street that's a far more practical aspect of it. Franchisees of one franchise system, think of it, let's say McDonald's and Burger King, franchisees will actually go into their competitor's location, observe employees, and poach them frequently. That goes on all the time. All of the anti-poaching that we're talking about here is related to one system. But the actual poaching that goes on by and large in franchise systems is across brands. And there's nothing that any of this affects. So the practical aspect of this for many in building foundation skills is allowing those employees to actually find higher wages and higher earnings. As I said, I'm not here to defend the business model, but I will say that that's the practical implication at the employee level, by and large, for most employees in franchise training.
Sorry.
Yeah, I would just, I mean, briefly to reply to that, I think we're making too much of the distinction between interbrand and intrabrand competition when we talk about the labor market. I mean, we have permissions for restrictions on intrabrand competition in the case of, say, territorial exclusivity in the output market, and the idea is that by permitting the suppression of intrabrand competition will enhance interbrand competition, but that there's no analog to that in the labor market that I'm aware of, and we shouldn't use the excuse that there's the potential to move to outside the system for why we should allow the suppression of competition through no poaching agreements within a franchising system. I mean, especially when there are many cases in which the employees themselves would say, no, the best prospect for an outside job offer is going to come from another franchisee absent a no poaching agreement because, this is the system that I've been trained on and that I'm best equipped to work for. So to take away that possibility and say, oh, well, they could just go across the street to a different franchise, I think that's, practically not relevant to the harm to competition that's actually taking place in the labor market.
Just two quick things to add. One, I think it's important to ask, to what extent the no poaching agreement is actually inducing increased training. So, every business has to do entry-level training for employees. That's an unavoidable cost. So and then when you're dealing with, workers who are occupying very low skill positions, I speak from some experience having worked at this kind of a restaurant in high school. For me, seeing the argument that, preventing an entry-level fast food worker from moving to another franchise encourages investment in a type of training that job requires just shouldn't really pass the straight face test, let alone the rule of reason. So that's an economics question, certainly. But just to come back to Samuel's hypothetical of the minimum wage where there's no maybe measurable damages or no price effect, another point we haven't talked much about is harm to non-price competition, which the antitrust laws also protect, and which is often quite relevant in the context of these no poaching cases. Oftentimes the reason a franchise, say a fast food franchise worker wants to go a mile away to a different franchise may have less to do with the pay increase and more to do with being harassed at work, being in an uncomfortable work environment, and having a different choice that worker values for non-wage reasons.
Thank you all. This has been a great discussion about franchise, and obviously there are a variety of views, and it's a complex business setting, so it's no surprise. We're running very short on time, but we would be remiss not to discuss one other complex business setting when it comes to assessing antitrust harm, and that's digital platforms and gig economy workers. So Marshall, I'm going to put you in the hot seat for a few minutes. And you've published some fascinating work about the relationship between the growth in the gig economy and the labor laws. And so I was hoping that you could maybe briefly describe the relevant history and then also some of the recent empirical research in this area.
Sure. So I think it's great to have a panel that's talking about franchising and labor markets and also the gig economy, because in my view, those two things have a lot to do with one another in terms of the evolution of the law governing both of them. So the very first thing I ever wrote about antitrust was about a private action against, at that time, Travis Kalanick, the CEO of Uber. Now it's the case is Meyer v. Uber Technologies. This concerns, it's essentially a direct offshoot of the fact that, at least at that point, Uber drivers had tried and failed to prove misclassification as independent contractors. So they said that they were in fact employees, given how much control they were under from the gig platform in 2015, late 2015, when that case was filed, that those cases had been unsuccessful. And so this antitrust case against Kalanick and Uber essentially says, well, if you're if the drivers are not employees, then why does Uber have the power to fix prices across all of these ostensibly bilateral transactions where the drivers are independent businesses? That's the claim. That's Uber's claim in defense to employment misclassification. Well, that immediately triggers the concern that they are violating the antitrust laws, and in particular violating a per se ban on horizontal price fixing if this app that fixes prices across a bunch of bilateral transactions is a horizontal price fixing arrangement. That case had a long history of litigation, got sent to arbitration eventually, and now it's about to be arbitrated finally next month. I believe there's going to be a hearing about it. So in all of the time I've been writing and publishing about antitrust from early 2016 to now, this case is now finally going to be heard on the merits, at least in arbitration, and that's gratifying to me. I think that raises this question of, well, if the business model of the gig economy labor platform that's premised on the fact that the workers on that platform are not employed by the platform, then that brings into effect all of the concerns that we might have about antitrust. So there's price fixing. I think there's a good case that the driver pay policies, or more generally even outside the ride-sharing context, that pay policies on labor platforms amount to vertical restraints that direct workers to supply labor in particular geographic markets or at particular times. These are ways of controlling the work that workers do, ostensibly outside the sphere of labor law, where if that degree of control were exercised, then the workers would be in return empowered with many rights as to hours of work, minimum wage, the ability to collectively bargain. What the gig economy labor platforms bring about is a situation in which the workers who are not who do not enjoy the rights of employees under labor law are also, at least to date, not protected by antitrust law vis-a-vis the anti-competitive actions of the platform that at least directs what they do on a day-to-day basis at work if it doesn't legally employ them. So there's the case Meyer v. Uber Technologies, and I think there's potential for other cases that involve essentially scrutiny of the policies of the gig economy platforms as to their allocation of markets, for example. I mean, just the very fact of the labor platform says, this driver has to serve this customer and the drivers cannot compete over serving that customer. That could be viewed as a vertical restraint, potentially subject to antitrust laws. The fact that the policies penalize multi-homing, even though the platforms claim that they permit multi-homing on the part of workers, the fact that in practice, if you don't supply 100% of your labor, at least within a given shift, to a certain platform, you will not be eligible for the bonuses and therefore make that shift not worthwhile. That is another restraint on competition that makes the supposition of multi-homing really not applicable in practice, and therefore these labor markets have a lot less competition going on in them than the platforms claim is the case. I think the issues that you want to raise this morning with respect to the firm-specific labor supply elasticity can absolutely be brought to bear on the matter of the gig economy labor platforms. In fact, some very good work has been done to date estimating supply elasticities to the ride-sharing market as a whole, as well as to the individual companies who provide ride-sharing services. This idea that the platforms have the ability to manipulate driver pay without much loss of labor supply on the platform gives them a great deal of market power that raises all of the concerns about anti-competitive behavior that we're here today to discuss.
I want to just go back and because you were talking about using the term multi-homing, and I want to make sure that everybody in the audience understands what that means. So maybe if you could describe multi-homing and just within the platform pay policies, how that provides an incentive.
Yeah, so multi-homing means that a single service provider on a platform, or I should say, a single service provider could at any given time supply their labor via one platform or another. So if you use the ride-sharing market, you might see that a car has a sticker for Uber and a sticker for Lyft in the car, and ostensibly that means that car is multi-homing or could be multi-homing because that driver might be driving for Uber or for Lyft. And in theory, what's supposed to happen is that they're receiving the possibility of taking up fares from one or the other and choosing the one that best serves them. The reality of it is quite different. I don't think there's that much multi-homing that goes on. I can tell you, I for one used to be a bike messenger, and there was no multi-homing there, even though I was not a statutory employee. I basically had to do what the dispatcher said and take the fares that were on offer, despite the fact that I did not have access to the benefits of employment status. And I think this idea that, undoubtedly multi-homing is of value, or at least the potential for multi-homing is of value to the drivers, but I think in practice, in the status quo, it is not as available an option as the public has been led to believe.
A lot of what you've talked about stems from this distinction between the classification of workers as independent contractors versus employees. And so how should we think about sharing economy workers? Do they fit well within the existing employee independent contractor dichotomy? I mean, what is the appropriate way to think about them?
Yeah, I mean, the existing independent contractor employee dichotomy is something that has not been static at all. So I don't want to give the impression that, there's this sort of like well-established categories and you're in one or you're in the other. And if you're not in one or the other, then something's wrong with the system. We have been eroding labor law in the sense that we have allowed many different work arrangements to be categorized as independent contracting that would previously have been categorized as statutory employment. And this is enabled by technologies that allow for supervision from afar, but it's also been enabled by the erosion of legal standards. And, at the very least, whatever you think about that evolution of labor law, I would say it certainly implies that antitrust has more of a role to play in the labor market than it once did, because if we're saying that all of this whole category of worker doesn't benefit from the protections of labor law, like minimum wage, in some sense you could construe labor law as, even more, regulating competition in the market even more so than antitrust law. Antitrust is sort of a minimal set of regulations about preserving competition in the labor market. If more and more workers are not protected by labor law, which recognizes the imbalance of power between workers and employees, then you're sort of throwing workers into the realm of antitrust, where they're, at least to date, are also not effectively being protected. And I think that represents a policy failure at the very least, if even recognizing the erosion of the traditional employment relationship.
California recently passed a law that requires app-based companies to convert in-state workers to full-time employees with benefits and wage protections. And following up on what you just said, how would you predict that this bill would change labor competition analysis for workers?
Yeah, well, I mean, so the companies have claimed that in response they will have to withdraw the ability of the workers to multi-home and force them to be exclusive to one platform or another. I don't buy that on their part. I mean, there's no reason why they would have to withdraw the ability to multi-home. I think, there are certainly labor arrangements that exist in the economy that are analogous to multi-homing that are fully consistent with statutory employment status on the part of workers, and that could be arranged. On the other hand, I would say it's pretty clear that the reason why the platforms have availed themselves of these sort of technology-based controls over worker behavior, as opposed to just saying outright, well, you have to only drive for Uber, you have to only drive for Lyft, is because they feared exactly the thing that's now come to pass, which is that they would then be forced to reclassify independent contractors as employees, or at least that the law aims at bringing about. I guess it hasn't actually made that happen as yet. I think, now so the companies could say, well, now that this thing has been passed, we do require exclusivity. In some sense, the legal risk of doing that has now been removed because the bad outcome has already occurred. But there's no reason why it needs to, and there could be a context, I would say, that arising, say, from a collective bargaining agreement under employment status that, multi-homing must be preserved in some form or fashion.
For those interested in this subject, there's been one trial to date on the employee independent contractor question in the gig economies. One case that's actually gone all the way to judgment. That's the case involving Grubhub. It was tried in front of Magistrate Judge Corley, and it was a bench opinion. So unlike a jury trial, you can actually see, a very extensive set of findings of fact. Not to discount Marshall's personal experience as a bike messenger and what it meant for multi-homing. For example, Judge Corley does have extensive findings on how that was working, at least in one geographic market, in the independent contractor versus employee context, to the extent the law clearly in California is changing, not merely because of AB5, but because of the Dynamex decision. It's, clearly a very evolving environment in terms of what's an employee versus what's an independent contractor. But for those who are thinking about this in terms of what's going to happen in the other 49 states, it's a nice counterpoint just to see, an actually fully developed factual record on how some of these things are working in practice.
So I cannot believe it, but I think our time is up for this panel. And not just because the next panel is supposed to start 10 minutes ago. This has been a fascinating discussion. I will say, personally, I am grateful to all of you for arriving today, for being as enthusiastic for the subject as I anticipated, and for having this really fantastic discussion. To echo something that Macon said this morning, it is an essential public good, and all of us are grateful for your time.